All right, American democracy. We're going to wrap up criminal rights today. The previous video was all about the Fourth Amendment, search and seizure. Today we're going to focus on the other amendments to protect you from the government during criminal proceedings. So again, if the government is trying to charge you with a crime, you have certain protections. So again, we looked at the Fourth Amendment. Today we're going to look at the Fifth, Sixth, Eighth, and a little bit of the 14th Amendment. Those all have protections that you have from the government during a criminal process. So starting with the Fifth Amendment, it does quite a bit here. It says that you cannot be held to answer for a capital crime unless indictment of a grand jury. So basically a large jury has to look at the evidence and the prosecution has to say, here's all the reasons why we want to charge them or indict them with a crime. And the grand jury has to say, yes, you have enough evidence to go indict them. You may have heard of that word indictment if you ever watch like Law and Order. That just means an official charge. So a grand jury indictment for a capital or infamous crime, typically a federal case or a major case. The next piece is you cannot be tried for the same offense to be twice put in jeopardy. We'll talk about what that means here in just a little bit. You cannot be compelled to be a witness against yourself, so they cannot make you testify against yourself during a trial. And then you have the right to due process of law. The idea that there has to be some procedure in place. If they want to throw you in jail, they have to give you a trial. If the school wants to expel you, there has to be an expulsion hearing. So there has to be some process. They can't just do it. And then the last piece we're really not going to talk about a lot today is private property taken for public good. So in theory, the government, not in theory, in reality, the government has the right to take your property, take your house, if they want to build a road or a school or a park, but they have to pay you for it. It doesn't really fit into our criminal aspect that we're talking about today, but it is part of the Fifth Amendment. So looking at the Fifth Amendment continued, again, no double jeopardy. The reason we have this is the idea that, without it, the government, if you're found not guilty, they could just try you again and try you again and again, and eventually some jury might find you guilty, and you shouldn't have to go through that. Basically, the government gets one shot at you. They better get all their evidence together, get the ducks in a row, and present it to a jury and get the best shot at you. So you cannot be tried twice for the same crime. Now, there are exceptions to this rule. You can be tried in two different levels of courts. So it could be a state court and a federal court. You could be found guilty in both. And a good example of that is Michael Vick right here. You may not be familiar with him. He was an NFL quarterback. And during his career, he got wrapped up in a case where he was in a dogfighting operation and dogs were being killed. And he was charged. And so he was charged in federal court. And then the state of Virginia, where the crime took place, said, well, wait a minute, we have laws against this, and so we're going to charge him in Virginia state court. So he actually got a year in federal prison and a year in state prison, and they actually let him serve both of those at the same time. So even though he got 2 years, he served them together and served 1 year. So that is still an exception. He was tried in two different courts. Other exceptions to this rule is, if a single act involves more than one crime. If I rob a bank and kidnap somebody and steal a car, they can charge me for each specific crime I committed, not just one. If a jury can't reach a verdict, if it's a hung jury, so if I'm on trial and the jury comes back and says, we can't decide, we can't agree, then they can put me back on trial again because I was not found innocent. I was not found guilty, but I was not found innocent, so they can try you again. Typically, if it's going to be a hung jury a couple times, they're probably going to end up dropping the case unless they find some type of new evidence. And then if I appeal it to a higher court, so if I'm found guilty of murder, well, I have due process, so I can appeal it to the next higher court. And I'm not necessarily tried again, but they look at my case again. Now, they can do that because I've asked them to do that. So if I appeal it to a higher court, that's allowed. The right against self-incrimination. This is where you hear people on TV shows and movies say, well, I plead the Fifth. This basically means, again, if I'm on trial for murder, I don't have to go stand up in the witness or sit down in the witness stand and answer the questions during my trial. Now, that might make me look a little bit guilty to the jury, but the judge is going to tell the jury they can't hold that against me. That's my Fifth Amendment right. I don't have to testify against myself. I can. If I want to go up there and answer questions, I can, but I have to take questions from both sides. If I'm going to take questions from my lawyers, then the other side has the right to question me as well. And that's why a lot of times, especially in big, high-profile cases, you think the Casey Anthony trial, the O.J. Simpson trial, they never go on the witness stand because they don't want the other side to question them. The Miranda warnings are all protections you have if when the cops detain you and they want to talk to you and they want to question you. You may have heard a lot of these in TV shows and movies. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney during questioning. If you cannot afford one, they will provide you an attorney, and then you have the right to stop questioning at any time. So you have all these rights. The real question is, when exactly do they have to read you these rights? Typically they're going to read you the rights when they put you in the squad car. But really, they don't have to read you the rights until they're actually sitting down and questioning you about why they arrested you. And they're called Miranda warnings because they're named after, I believe it was Ernesto Miranda, was a guy in Arizona they arrested for, I want to believe it was rape, or it was a pretty bad crime. But they did not tell him he had all of these rights, and he answered all their questions. And then they used all that information against him in court, and he was found guilty. But then he appealed it, saying, wait a minute, I didn't know I didn't have to talk. He thought he had to talk, and so they threw the case out and let him go because the cops have violated these rights. And since that point, the Supreme Court has established a remedy with the idea that the cops have to read you these rights when they're going to question you. Due process is mentioned in the 14th and the 5th Amendment. It's the idea that the government has to follow proper procedures if they're going to try to take away your life, execute you, your liberty, put you in jail, in prison, or property. They want your property. There has to be some type of legal procedure. Again, a trial, a hearing. They can't just do it. They can't just throw you in jail. They can't just execute you. They can't just knock on your door and say, get out of your house. We want to tear it down and build a road. There has to be a legal process in place. And if I jump ahead to this slide, obviously the more punishment, the greater the punishment you're facing, the more due process you have. So, if they're going to try to execute you with the death penalty, you have the most due process possible, right? They're going to put you on trial. If you're found guilty, you're going to have multiple appeals built into that process because that's the most severe punishment, is taking away your life. Way back here, a minor traffic stop, due process is not nearly as much. Going back here, the burden of proof. You are innocent until proven guilty. Remember, the government has to prove you did it. So during the trial, you don't have to prove your innocence. Now, it can help if you can, right? And most people are going to try to provide some evidence proving they didn't do it. But in the end, you are innocent until proven guilty. So they have to prove you did it. You don't have to prove you didn't do it. Again, it helps if you can. Ex post facto law is just the idea that the government cannot pass a law to get back at you or try to charge you with something that used to be illegal. A good example would be like maybe, currently right now, it's legal to talk on my phone while driving in Wisconsin, but let's say tomorrow it becomes illegal. They can't come back and write me a ticket for doing it today. That's ex post facto. It also works in reverse, right? Think of California, or a lot of that states, actually. Illinois recently legalized marijuana for recreational purposes, but you also have a lot of people in jail for marijuana crimes. So those people don't automatically get out of jail now that marijuana is legal, because it was illegal when they committed the crime. Now, some states are taking efforts to maybe let some of those people out of jail, but they don't have to, because again, it's what was the law when the crime was committed. All right, 6th Amendment. So this amendment really deals with your rights during a trial. You have the right to a speedy and public trial, which again is kind of vague language. What does speedy mean? We'll get into that. Public, you're going to want your trial public. You don't want it closed off to everybody because then who knows, what the government might try to do to you. You want to make sure that people can see it to make sure your rights are not being violated. You want an impartial jury, so a jury who does not know you or know the people involved in the case, or they're unbiased. You have to be informed of the nature and cause of the accusation, like why are they arresting you, why they charge you. You have the right to confront witnesses. So if somebody's going to get on the witness stand and testify against me, my lawyers have the right to confront them and question them as well. This does not mean I have the right to go confront them outside and into a fist fight in the street. It means my lawyer has the right to question them as well. And here is the assistance of counsel. If you cannot afford a lawyer, one will be provided for you. This was also mentioned in the Miranda rights. If you have the money to afford a lawyer, you could pay for your own. If you cannot afford one, they will give you a public defender. Public defenders are very good lawyers. The one knock about having a public defender is just sometimes they're overwhelmed. They get a lot of cases. They're trying to balance a lot of cases at one time. Typically, there's not enough public defenders out there. Like, we need more of them. And so they're trying to juggle a lot of different cases, where if you can pay for a private attorney, typically they have fewer cases. Continuing the 6th Amendment, again, your right to a speedy public trial, your right to a lawyer, like I just talked about there. some specific details, basically 100 days, like speedy public trial. Speedy is kind of a vague term. In 1974, the court ruled that basically 100 days from when you're arrested to your trial is considered a reasonable time for you to prepare your case and the government to prepare their case. Again, you want the trial open to the public. You want people to see what's going on. Typically, you want an impartial jury. If you're 18, you may have to serve on a jury because that's kind of like your basic civil duty. You don't have to vote. I mean, hopefully you do vote, but you have to serve on a jury. That's like the one legal requirement you have as a citizen. If you get a notice in the mail for jury duty, you're probably going to have to do it because if you're ever on trial, you're going to want a jury, and so it's fitting that you have to serve on somebody else's. Some people get called multiple times for jury duty. Others never get called for it. It's all kind of random. Again, they have to tell you what they're being charged with. And compulsory process is the idea that you can force people to testify. So if I'm on trial and I know somebody who has information, my lawyer can subpoena them to make them show up to testify in court. Eighth Amendment, it's pretty short, right? Excessive bail should not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So what does that mean? Well, it forbids excessive bail. It has to be reasonable. It has to match the crime. If I am arrested for shoplifting, they can't put me in jail and give me a $100,000 bail, right? That's not equivalent. It has to be, it has to match the crime. If I'm arrested for murder and they want to make my bail $1 million, well, that might be reasonable. That might happen. So it typically has to match the crime. Again, bail is property or money that you can put up to make sure you're going to show up. Remember, you shouldn't have to sit in court. I'm sorry, let me back up. Why do we have bail? Well, again, you're innocent until proven guilty. Just because you're arrested or even charged with a crime doesn't mean you're guilty. You have not been proven guilty in court yet. And so you shouldn't have to sit in jail until that point. And so you should be able to bail yourself out. And also you can help your lawyers prepare better outside of jail than sitting inside of jail. So bail is basically, here's some money or property. I promise to come back. I promise to show up in court. And if you do, then it's good. If you don't show up, they keep that and they put a warrant out for your arrest. Now, we don't give everybody bail. Preventative detention, right? If you're in jail for a major crime, you're a flight risk, you're a danger, they're just going to deny you bail. You're going to sit in jail. That's preventative detention. And on the opposite end of that, again, like for shoplifting, they're not going to make you sit in jail. It's basically going to be a signature bond or your personal recognizance where you basically promise to show up, typically for a low-level crime. The other part of the Eighth Amendment is it forbids cruel and unusual punishment. Again, a vague phrase. What does that really mean? It must not involve unnecessary infliction of pain and must not be grossly out of proportion. So again, for shoplifting, they can't chop your hand off. That doesn't match the crime. Typically, the punishment has to match the crime. And again, it was intended to prevent torture that went on when we were part of England way back before the American Revolution. And so this is a highly debated topic, specifically around things like the death penalty. In 1972, the Supreme Court banned the death penalty. They argued that it was cruel and unusual punishment. So anybody in 1972 who was in prison and who had been sentenced to death was no longer on the death row. It was changed to life in prison. They were not let go. They just got life. But only 4 short years later, the Supreme Court changed their mind and said, you know what, it is constitutional. So since 1976, we have had the death penalty in the United States. Today, about 31 states have the death penalty. So a majority of states do, but more and more states have started to get rid of it for a number of reasons, mainly not necessarily because it's cruel and unusual, but there have been more and more cases where maybe somebody was proven innocent after they had been executed or while they were sitting on death row. And so a lot, DNA technology is much better today than it was 30 years ago. And so there's been dozens and dozens and dozens of cases where they've actually proven people innocent who had been executed or were sitting there on death row. So, obviously a lot of people think that's an issue, and so some states have dropped it. Today, there are 5 legal methods, even though they're not all used. Typically, the method used today is going to be lethal injection. They give you a combination of drugs to cause your death. That's the most common way. Most states, almost all states, use that method. All these other ones are like backups. If they can't get the drugs to use the lethal injection, they might use one of these other methods. And so if you look at this map here, the red states all have the death penalty. Texas is number 1. They execute more people than any other state. Florida is probably right behind with Virginia and Ohio. Those are probably the next 3 states. They use the death penalty quite a bit. Light blue states do not have the death penalty, like Wisconsin has not had the death penalty in a long time. Dark blue states have the death penalty, but the governor basically says we're not going to use it. And I think California now has actually flipped to this blue color as well, where basically, and actually California has the most people on death row. Texas executes the most, but California has the most people. They just don't use it very often. All right, that's criminal rights, 5th, 6th, 8th, 14th Amendment. Have a great day.